We need to talk about defense distributed in the Central District of California today. It's important to understand what happened out there and why, in my view, the decision was wrongly decided and how we can avoid these kinds of problems in the future. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. And we really would appreciate the subscription. We're trying to hit that 100,000 subscriber mark. It'll make a big difference with the algorithms in social media. All right, you guys know a couple weeks ago, a case called Defense Distributed versus Bonta was decided in the Central District of California by a judge by the name of Judge Wu. Got it wrong. But I want to talk about how he got it wrong, why he got it clearly wrong, and how to make sure this doesn't occur in the future. By the way, I'm not suggesting in any respect that Defense Distributed did anything wrong with their legal arguments or anything like that. I just think that the judge got it wrong, so I want to use this video kind of to educate people, including judges as appropriate, about how to apply the Second Amendment. Because I think that what Judge Wu did in this case really was not consistent with the proper application of the United States Constitution and Supreme Court precedent, and I'll tell you why in just a second. To begin with, the Defense Distributed case was essentially a challenge in California to a ban that prevented anybody but FFLs, people in the business of firearms, from using CNC machines, basically a technical tool and machine that you can use to make firearms. Now, without getting into the details of this particular case, suffice it to say that the state of California really admitted that these CNC machines are used for making firearms. And the reason why they essentially had admitted this almost as a question, not just as a question of fact, but as almost legislation, is you see when California passed this law, it specifically carved out an exception. It said that these CNC machines, which stand for computerized numerical code machines, won't bore you with the details of that geeky stuff. That'll be for the engineers on other channels to talk about. But basically, it specifically said that CNC machines can only be used by federal firearms licensees, manufacturers, importers, people in the business of firearms. But if you're an ordinary person and you try to use a CNC milling machine for the purposes of making firearms for yourself, then that's a problem under a California law. So Defense Distributed brought this lawsuit on Second Amendment grounds. I think that's a very strong arguments associated with this. But what I want to talk about is what the judge did here and why it's wrong. What the judge did here was he tried to play this game, in my opinion, of being a hyper-textualist, okay? And what I mean by that is he says, okay, well, I read Nysurpa versus Bruin, the Supreme Court decision in June of 2022, and what it tells me is there's a process I have to undertake to apply the Second Amendment to modern-day gun control laws. And he says the first step is I take the plain text. So what Bruin said, the plain text. I take the plain text, and then I apply it to the situation at hand. And if the plain text is implicated or infringed upon or fingers are touched with the modern day gun control law, then the burden shifts to the government to demonstrate there's historical analogs to justify the modern day gun control law. But what Judge Wu did here is he played a little game. He says, well, in my opinion, he played a little game. He says, oh, well, you know, the challenge here brought by Defense Distributed is saying that we have a Second Amendment right to make guns, to manufacture guns, whether for ourselves or others. We have some sort of Second Amendment right to make guns for ourselves, for example. And if we want to buy a CNC machine to do it, we should be allowed to do it under the Second Amendment. So what Judge Wu said is, well, I'm going to take the advice and the instructions from Nysurpa versus Bruin and apply it. Well, I read the text of the Second Amendment. It says, the operative clause at least, the right of the people to keep and bear arms shall not be infringed. And when I read that, the right of the people to keep and bear arms shall not be infringed, I don't see the word manufacturing. I don't see the word making. He's like, I don't see any of that stuff in the plain text. Therefore, the plain text is not implicated by a ban on CNC machines being used by people to make their own firearms or whatever the allegations were in that context, and therefore I'm going to dismiss the case. I don't even have to shift the burden to the government to demonstrate a historical analog in 1791 at the time of the founding. Why? Because the plain text of the Second Amendment is not implicated. Therefore, the plaintiff loses. Defense Distributed loses. Well, okay. That's what the opinion says. I read it. It's obviously not very persuasive. So either Judge Wu is playing a little coy here, as I see it, a little cute, or he maybe doesn't fully understand how constitutional law works when you're dealing with things that are not expressly in the Constitution. Let me explain. You see, when the Supreme Court in Nyserpa versus Bruin said that you first apply the plain text, that is not a license. That is not permission for lower courts to read the Second Amendment in a vacuum and make it up. In other words, the Supreme Court, you see, has already told the lower courts what the Second Amendment means for all intents and purposes. The essential parts, right? Think about it for a second. In the case of Heller, McDonald, Caetano, and Bruin, the Supreme Court has actually talked about and defined and interpreted the text of the Second Amendment, the right of the people to keep and bear arms. And the Supreme Court itself has said, for example, that the people mean all Americans. That's not me. That's what the Supreme Court decision in Heller, all Americans. It specifically defines arms as all, quote, all instruments that constitute bearable arms, close quote. That's Heller. It defined keep arms to mean have weapons. Not me. That's what Heller said, the Supreme Court. It defines bear arms in Bruin as carrying a weapon for the purposes of offensive or defensive action. That's what, bear arms means, to carry a gun. Shall not be infringed means it's an unqualified command. You can't infringe upon it. Okay? So what Judge Wu did here is he's like, well, I'm just reading the text and I don't think it applies. But he didn't take the next step and say, what does the Supreme Court tell us these words mean? And I'll tell you the best evidence, I think, that the Judge Wu got it wrong is if you actually look at page 6 of the opinion. You probably don't have it in front of you. But this is where he plays this game, as I see it. He writes, he specifically says, there's nothing in the Bruin's plain text. Immediately defense distributor talking about historical tradition of making your own guns. And then he goes on and literally talks about the language of keeping and bearing arms and the language's ordinary meaning. Here's the key part. Judge Wu says, in his opinion, specifically, that the Second Amendment's language includes a guarantee of the individual right to possess and carry weapons. Think about that. He's quoting Bruin, and this you'll see why this is so important and why it shows that he got it wrong against our right to keep and bear arms and our right to make guns. Judge Wu says that Bruin and Heller note that the Second Amendment's language includes in its normal and ordinary meaning a guarantee of individual right to possess and carry weapons. To possess and carry weapons. Okay. Now, this is not rocket science, folks. What does it mean to possess and to carry weapons? It means just that, right? To possess means to have, to pick up, to have. And to bear means to carry. But to keep anything, including an arm, including a firearm, and to carry anything, including a firearm, guess what? What does it presuppose? Necessarily. It necessarily presupposes that you have the right to get it, to acquire it. You can't keep something, you can't have it, you can't possess anything if you don't first acquire it. We're not born with guns in our hands. So how do we get a gun under the Second Amendment or any kind of arm under the Second Amendment? We're born with nothing. So we have to acquire it to exercise the right. This is a no-brainer, right? And it's basic constitutional law. Going all the way back to McCulloch versus Maryland. We'll talk about, I'll give you the quote for that in a second. But basically, Judge Wu says, I read the text, it doesn't say you have the right to make your own firearm. And it does say, effectively, that you have the right to acquire it. Now, you can play a game and says, it doesn't actually say that. But I analogize this to like a little kid that's playing games with his parents. So when the parent says to a little kid, pick up the trash. Now, we know what that means. Pick up the trash and throw it out. That's what it means. But, a little kid might pick up the trash and drop it and be like, you told me to pick it up. I picked it up and dropped it. I did exactly what you said. To me, Judge Wu's doing exactly that. He's essentially a child who's been told by the parent, pick up the trash. And he's like, I picked up the trash. That's plainly what I did. That's the plain text of my command. I picked up the trash. I didn't have to throw it out. But see, that's not true. Because, again, if he had read Nyserpa versus Bruin and Heller and McDonald, what do those cases all say? It all says that the purpose of the Second Amendment, the right to keep and bear arms, is to have firearms for the purpose of self-defense against all forms of tyranny. Again, that's not my interpretation. This is what the Supreme Court has literally said in its holding in Heller, McDonald, and Bruin, that the purpose of the Second Amendment is private self-defense against all forms of tyranny, whether it be governmental tyranny, whether it be a domestic insurrection tyranny, whether it be a foreign invader tyranny, whether it be animal attack tyranny, whether it be a common criminal tyranny, whatever it is. The Second Amendment is about effectuating the right of armed self-defense in anticipation of a confrontation, either inside the home, which is Heller, or outside the home, which is Bruin. Now that, you show me where the words self-defense appear in the plain text of the Second Amendment. It's not there. So Judge Wu would be like, where do they get self-defense from? It doesn't say self-defense in the Second Amendment. That's absurd. And it's a game because as a lower court, Judge Wu is what's known as an inferior court under Article 3 of the United States Constitution. Article 3 defines inferior courts as all other courts in the United States other than the Supreme Court. And the Supreme Court has defined the Second Amendment as being designed for self-defense. And they've defined all those terms that we just went through. So Judge Wu is not being asked to read the plain text in a vacuum and pretend I don't know. I don't know what these things mean. It's just not clearly there. No. His job is to read the plain text of the Second Amendment as understood, interpreted, and defined by Supreme Court precedent, which goes on literally for hundreds and hundreds of pages interpreting these basic words that we've just gone over right here on a YouTube channel. And that's what Judge Wu should have done. And of course, once you realize that the right to keep and possess includes the right to acquire. Now, the right to acquire could mean you make your own gun. The right to acquire can mean you inherit your own gun. The right to acquire can mean you buy your own gun, right? The right to acquire could mean you receive a gift of the gun. But you have to have the right to acquire. Now, this is not some, made up thing that I'm saying, hey, it just makes common sense. It does make common sense. Take the word of Chief Justice John Marshall in the early 19th century, one of the most famous, maybe the most famous Chief Justice of them all, the U.S. Supreme Court. John Marshall wrote in McCulloch versus Maryland the following. Tell me if you think this might have been helpful for Judge Wu to have reflected on in the defense distributed case. The Supreme Court wrote, McCulloch versus Maryland, one of the most famous Supreme Court cases ever, creating the precedents associated with what we now understand to be the Supreme Court and its powers. They write, quote, a constitution to contain an accurate detail of all the subdivisions of which its great powers will admit and of all the means by which they may be carried into execution. You hear that? And of all the means by which they may be carried into execution would partake of the prolixity of a legal code and could scarcely be embraced by the human mind. It would probably never be understood by the public. Its nature therefore requires, and this is key, its nature therefore requires that only its great outlines should be marked, its important objects designated, and the minor ingredients which compose those objects be deduced from the nature of the objects themselves. Now, the first two words are critical to that language I just read. What is it talking about? Here's the first two words, quote, a constitution, close quote. And what exactly is a constitution? Well, we know the Constitution, it's a body of text, it's a body of words. So this opinion from the Supreme Court going on, and there's many others after this, right? There's not the only one that basically says that you have to look at the text of the Constitution, and anything that's necessarily implicated by they is also protected. This is not making stuff up. You're not trying to make up a right to an abortion. You're looking at the right to keep and bear arms and drawing what's necessarily implicated from that, which would include the right to acquire them. But let's talk about some other examples of how absurd this is as I went through Judge Wu's decisions. So, for example, he says that try as you might, he writes, try as you might, you will not find a discussion of these concerns about making your own guns or any such rights in the plain text of the Second Amendment. Okay, let's think about that. Let's apply that to the other aspects of the Constitution that the Supreme Court has found that we have rights to. Let's talk about the First Amendment. So we have a right to freedom of the press. Well, the right to freedom of the press. So does that mean the federal government could ban printing presses? You say, well, you have a right to freedom of the press, but we can ban printing presses. Or we can ban ink, right? The First Amendment doesn't have the words ink. The First Amendment doesn't have the word printing presses. The First Amendment doesn't have the word cell phone. The First Amendment doesn't have the word telephone. The First Amendment doesn't have the word internet. So then does that mean we can bar the New York Times and Breitbart from using the internet and emails to communicate, to report on the news? Or do we think that might violate the freedom of the press if the government passed a law saying that news organizations may not use the internet, email, text messages, phones, printing presses, ink, electricity, whatever? None of those things I just discussed appear in the plain text of the First Amendment. What about the word church? I don't see the word church in the First Amendment. Does that mean that the federal government could ban a church or synagogue or mosque? Well, Judge Wu would say, well, under the plain text of the First Amendment that talks about religious freedom, it talks about religious freedom. It doesn't say the church. It doesn't say church. It doesn't say synagogue. It doesn't say mosque. Therefore, when I read the plain text of the First Amendment involving the religious protections, it doesn't use those words. So, of course, I don't see why government can't ban churches, mosques, synagogues, because it's not in the plain text of the First Amendment. How about the Sixth Amendment, the right to confront witnesses, the right to, counsel, right? The criminal procedure statutes. What about all those? Well, what about, could, for example, a lot of people get arrested. They go to jail before their trial. They don't get bail, whatever. Okay? Their lawyer has to meet with these people in prison to sit down with them and prepare for their defense at trial. So could the government pass a law that says lawyers, criminal defense lawyers that have to go to prison to defend their clients at a trial or on appeal, they cannot bring pens or papers or writing instruments into the prisons. They cannot take notes. We're going to ban them from bringing paper in. We're going to deny them the ability to have a private meeting. We're going to force them to have a meeting with their clients surrounded by other people because the text of the Constitution and the Bill of Rights doesn't talk about ink. It doesn't talk about pens or papers. It doesn't talk about printing presses. It doesn't talk about any of this stuff. So you see the craziness associated with Judge Wu's game here. Now, he does try to say, and he quotes, well, Bruin says I have to do the plain text. Yes, you do, but the plain text, it doesn't mean you get to make it up. You have to read the plain text of the Second Amendment as it was understood and given to you by your version of Moses, who's come down with the Ten Commandments in effect, which is that the constitutional text of the Second Amendment, as interpreted, defined, and laid out in literally hundreds and hundreds of pages of Supreme Court precedent, Heller, McDonald, Caetano, and Bruin and beyond. But Judge Wu simply refused to do that, saying, oh, it doesn't mention the plain text. Therefore, the Second Amendment is not implicated. Therefore, I don't have to shift the burden to the government to demonstrate a historical analog to ban the tools associated with making firearms such as CNC milling machines and the like. Okay. Bottom line is, Judge Wu, in my opinion, got this wrong. I know he's in California. I know you have issues in California. I'm not shocked. But the good news is that I think as we get this kind of word out, I get this information that I'm talking about on this channel out, and other people talk about it, I think that other judges, and maybe even Judge Wu down the road, when he has an opportunity to reflect on this and think about this from a more commonsensical point of view, because the truth is a lot of judges don't have a lot of experience with constitutional cases. They're a little bit unusual. They're not the bread and butter. A lot of the cases are really commercial disputes over contracts. So, sometimes you do have to educate judges on how the Constitution works. They may not be completely familiar with it, their background not be such. I don't know what Judge Wu's background is. But again, I think the bottom line is this, that there is a right to make your own firearms. I think that is clearly necessarily implicated in the Second Amendment for a whole host of reasons we can talk about in other videos. And I think there's already been one decision out of the district court in Delaware, in Wilmington, Delaware, the home of Joe Biden, that actually came out and said, indeed, that there is a Second Amendment right to make your own firearms, which makes a lot of sense. You don't even need to get into the history of it. There's a long history of making your own firearms going all the way back to before the founding of the United States, but you don't even need to get into that because, to me, the text of the Second Amendment clearly implicates the right to acquire guns. And, of course, one of the ways you acquire guns is the right to make them. Nothing compels me to have to go buy it from someone if I can make it, right? That's like saying you have to go to the store and buy your food when I can perhaps make it myself. So anyway, bottom line is, it's an important topic, this sort of hyper-textualism game. I think you'll see more of this from the anti-gun lobby. I don't think it will work for the reasons I've articulated today, but I did want to talk about this defense distributed case because it's the kind of absurd analysis that we may see out there, and we better be ready to rebut it, and I suspect our Second Amendment community will be ready to do so. Okay, folks, I hope you learned something. If you haven't subscribed to Four Boxes Diner, please do so. Again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.